Estate planning is a term that refers to taking action and preparing documents that may be needed if bad things happen, like you were to die or you were to become incapacitated and no longer able to deal with your financial affairs. So these are concepts that are important and that many people like to procrastinate. It's over half the people in the United States who are adults do not have an estate plan. So they have not protected their family, because the real bottom line is that if you don't have an estate plan, you're not protecting your loved ones. Because if you die without an estate plan, bad things can happen, and maybe the wrong people might even inherit your assets. So when we do an estate plan for our client or our client's husband and wife, what we're doing is preparing a set of documents that are going to be signed by each of them, and then they become legally binding documents that deal with different phases of an estate plan. So what we like to do is, first of all, we offer a free consultation. If somebody wants to have questions answered about wills, trusts, and estate planning, we're happy to do that. The way that you can book a free consultation with me or my son is to go to our online calendar. You can book an in-office, a phone, or a Zoom video consultation. It's free, and we're going to answer all your questions about wills and trusts and estate planning. Because let's face it, most people don't like to think about it, they don't like to talk about it, and they don't know very much about estate planning, wills, and trusts, and what all that means. But that's what we're here for. We want to help you understand the concepts and then take action that's going to protect your family. So the first thing is, during our consultation, we're going to answer all your questions. We're going to show you the end product that we give people when we do an estate plan, which is a 3-ring binder with all your documents organized behind tabs. We're going to explain each document and then answer any questions that you have. So let's just talk for a minute about the primary documents in our estate plan. First is the trust. The trust is a document that says who's going to be the trustee in charge of your assets if you die, who's going to be the beneficiary or beneficiaries who inherit your assets if you die. So that trust agreement causes the assets that are in the trust to pass automatically on death to the person or people that you've named in your trust agreement. Now, if you're married, then typically what most people do is have the assets continue to be in the trust where the surviving spouse is the sole trustee and beneficiary. But when the surviving spouse dies, then the trust provides who inherits at that time. So that's the trust. Now, we also prepare a document called certification of trust. That's a short document, but it's something that you give people whenever they ask for your trust agreement, because you don't want to give people your trust agreement. It's confidential, and so they'll be happy if you give them the certification of trust, because it says who the trustee is and the date of the trust and the name of the trust and the trustee's powers. So the next document we prepare is called healthcare power of attorney. And this is a document that says who's going to be the person to make medical decisions for you if you can't. So if you're in a coma and you can't talk to the doctor's going to ask the person first in line on your healthcare list, should I operate or not operate? Then we prepare a HIPAA authorization that also gives your healthcare agents the right to get information about you from the doctors, because there's a federal law called HIPAA that says the doctors can't just willy-nilly give out information about a patient. Then we do a last will and testament. The only purpose of the last will and testament is it says that if you die and there's any assets that are not in your trust, then put those assets into the trust. So if a probate's necessary, the end result of the probate is the assets that went through probate are put into the trust. The financial power of attorney designates a person who can make financial decisions for you if you're unable. Then you can have a number 2 in line, number 3 in line. But if you lose your mental capacity, let's say you're in a coma, the person who's named on your financial power first in line has the ability to write checks on your checking account, can make payments on your mortgage, on your car, whatever. And so that's the purpose of the financial power of attorney, is to designate somebody to deal with your financial affairs if you're incapacitated and can't do it. Well, one of the mistakes that I see over and over again, and I really hate to see it, is people just don't do an estate plan. Many times they don't even think about it. They put it at the back of their mind, because let's face it, we don't like to think about death. And I mean, my own personal experience, I was flying combat missions in the Vietnam War in 1972, and the Air Force would make a free will. I could get a free will. So here I am flying combat missions in a war, and I didn't do a will. And the reason I didn't do a will is because mentally I thought, if I have a will, that means I'm going to die. And I didn't want to have a will because I thought maybe that'd make the better chance that I'm not going to die. But let's face it, that's not being realistic. We're all going to die. We all need to plan in advance. And unfortunately, too many people don't. I mean, I had a wonderful client. He was a client of mine for 6 years, a dentist. And I had formed 6 companies for him. He had 6 very successful companies, and he was worth a lot of money. And for 6 years, I kept asking him to do an estate plan. And he kept saying, yeah, I'm going to do it. Yeah, I'm going to do it. And then he went over to LA one weekend, and he died in his sleep over there. He had a wife and 2 young children. His wife knew nothing about his business. She didn't know anything he owned. He had $9 million in life insurance, and his wife didn't even know that. So it was just a disaster for the family. They had to do a probate, but the bottom line is the wife was in the dark and she didn't know anything about anything that the husband had. And so you don't want to do that. I mean, worst case scenario is you don't even have a will or trust, and so maybe the wrong person inherits. Well, if you have a family you need to protect, or if you have loved ones, a significant other, children, you need to take action to protect those people in case of your death. And the biggest problem that we see is people just procrastinate and they just don't want to do it. And unfortunately, sometimes they die before they end up signing their estate plan documents. We have a lot of young people ask us, should I have a will or a trust? My answer is, you probably should. First of all, it also depends on what a person has in the way of assets. So let's take a young person who doesn't have a significant amount of assets. Well, what that person needs, not so much a will or a trust, because if they die without a will or trust, their assets are going to go to their parents. So if they don't want their assets to go to their parents, then that's when they need the trust, because now they can say assets go to siblings or go to significant other or somewhere else. But when people don't have significant assets, they do need not necessarily a trust or a will, but they need a healthcare power of attorney, because that's a document that says who's going to make medical decisions if the young person is unable. They also need a financial power of attorney where they designate somebody who can deal with your financial affairs if they're incapacitated or in a coma. And then they need a living will. That's a document where they instruct the hospital to pull the plug if they're brain dead, being kept alive by a machine. So those ancillary documents there are particularly important for young people who don't have significant assets. And then, of course, a young person does have significant assets. That's where the will comes in, or the trust, even better, and the trust is going to provide who inherits. But remember, if you don't have a will or a trust and you're an Arizona resident, all your assets are going to go to your spouse if you're married and you have children with your spouse. But if you have any children that were not children of your spouse, assets are going to go one half to your children that are not children with your spouse, and the other half go to your spouse. Now, if you're not married and an Arizona resident and you die, then if you have children, everything goes to your children. If you have no children, everything goes to your parents. But if your parents are deceased, then everything goes to your siblings. So if that plan that the state of Arizona has created for you is not what you want, then you need to have a will or a trust that has your plan on who inherits the assets that you want to inherit after you die. Estate plans are documents that are signed as of a certain date and effective as of that date. Now, things are going to change in the future. Over time, as you know, people die. You meet new people. You decide that maybe you don't want somebody to be a successor trustee of your trust, or maybe they die and you want to change the order of your successor trustees. Or maybe you want to disinherit somebody, or maybe you want to change who gets what. But your changes to your estate plan are changes that need to be documented by amending your documents. So it's relatively simple to make all these changes, to change a trustee or to change a beneficiary or to change who is going to make medical decisions if you're unable, or who's going to deal with your financial affairs if you're incapacitated. All of those changes are easily made through amendments to your existing documents. And we are happy to make amendments, and we even have a little questionnaire that people can fill out if they want to hire us to prepare amendments to their estate planning documents, including their trust. We do send out an email to our estate planning clients every 6 months, reminding them to review their existing estate plan, and then if they want to make any changes, to fill out our online form and tell us the changes they want to make so that we can generate their amended documents to update their estate plan. Because you always want your estate plan to be current and deal with the issues that you want at that point in time. You don't want to have a 10-year-old estate plan that has incorrect people named, or people that maybe are deceased. So keep your estate plans updated from time to time as necessary. Yeah, if you have any questions about wills, trusts, estate planning, amending estate planning documents, and you can make an in-office, phone, or a Zoom video conference. And these are free conferences where we're happy to answer any questions about wills, trusts, estate planning, and any other questions that you may have. So just book an appointment time so we can answer your questions at no charge.